Hello, Shane McCusker here, Intelligence Software. I am delighted today to be talking about POPI, privacy and personal information, and I'm joined with Roly Borman, President of APSO, and an expert on POPI and a regular runner of workshops to help recruiters in South Africa prepare themselves for the upcoming legislation. Roly, I'm going to turn it over to you with the first question. Tell us what POPI is, when it's coming in, and what we can do about it.
Okay. Hi, Shane. Thanks for the opportunity. POPI, the Protection of Personal Information Act, has been enacted in South Africa, although it is not yet in force. I'm expecting that towards the end of the year, all of the conditions that the legislation set out for POPI to become effective will be in place, and it will be 12 months from that date that it actually becomes law. Notwithstanding that, what we're encouraging our members to do is to use POPI as though it was law, because it's good for their business to protect themselves and to protect their fees as they go about their daily operations.
So POPI is coming in, but it's not in yet. It's very reminiscent of the European legislation GDPR that came in last year, 2018, and caused us all sorts of fun and games to try and understand the legislation, the risks associated with it. But in actual fact, it highlights a bigger issue, which is about privacy and data protection. And GDPR, like POPI, shouldn't be feared by recruiters particularly. It's a mechanism for us to really protect ourselves. Would that be correct, Roly?
So when GDPR became effective, there was suddenly panic here saying, oh yeah, but some of our clients are actually have a European base, or we might be sending CVs across jurisdictions and they might be going into a European jurisdiction. So everybody got into a panic about that. So I then looked at POPI and compared it to GDPR. And in fact, they are really very similar in most respects. So I think you're right. Don't panic about it. You can use it to protect your business and make sure that by staying within the confines of the law, be it GDPR or POPI, that's the best way to operate. Work as though it was in place now.
So even though it's not in place, you're thinking that it should be impacting on people's work processes. We were talking earlier on, it's a little bit like if legislation was coming in for dangerous driving, just because it's not in yet doesn't necessarily mean you should be driving dangerously. The ethos behind POPI is well worth implementing. So what are the main things that people need to think about if they want to be compliant or in line with POPI?
So let me just have a look at my notes here, because there were 8 principles that came in. One's accountability. The person that holds the information must protect it. There is a processing limitation. You may not deal with somebody's information without their consent. You must deal with it for a specific purpose. And in our case, the specific purpose obviously is recruitment. Limitation on further processing. So there is a limitation on further processing. I think collecting someone's information is processing as defined. But then when you send the CV out to a client, that means that you're further processing that. So you need consent for that. Information quality. We need to make sure that the information we're releasing is of a good quality, but I think that is a good recruitment process anyway. You need to interview your candidate and make sure that the CV you send out represents them fairly and properly. Security safeguards. We need to safeguard in 2 ways. The physical safeguarding of CVs. So you walk into somebody and you hand them your CV. They need to safeguard that physical copy. I don't know why people keep physical copies these days, because we have IT systems to take care of that. So if you have CVs lying around, make sure when you go home, you lock them up that kind of stuff. But when we put CVs on an IT system, we need to make sure that that is safe and secure. A lot of people have service providers that hold their information for them. Maybe they need to get a certificate from that service provider to say, yes, we're taking safeguards against theft or improper use of the CVs that we're holding on your behalf. Because when the person goes to the regulator and says they misused my information, and you can't give an assurance to the regulator that you took reasonable precautions to make sure that their stuff was safe, you could be in the high jump, and you don't want to be there. Yeah, that pretty much sums it up, the very overview.
Rolly, if I can ask you a specific question, talk to me about consent, because this was a big issue with GDPR and what was going on then. A lot of recruiters thought that they needed specific consent from people to store their information. I don't know if that is the case or not. What are you recommending?
I think that storing information is one thing. And if I have your CV, let's say I got it from LinkedIn, and I decided to put it onto my database. Do I really need your consent to do that? If you want to be really safe, yes, do. But I don't think that's the big issue. The big issue is you have to make sure that once you put it into your database is secure and somebody can't steal it out of there. Now, I think the moment of truth comes when you want to send that CV to a client. Now you need consent, because now you're putting it out there, or you further processed it. Whether you call it processing or further processing doesn't really matter. But I think once you've dealt with that person's information by actually sending it to a client, I think that's the moment of truth, and that's when you need consent, preferably in writing.
But if we're looking for consent, this is really best practice anyway. A recruiter should not have been sending out candidate information without the candidate's permission to do so and their knowledge of who it was you were sending stuff to. Maybe one of the areas around consent was there's other aspects of POPI as well in terms of openness and in terms of informing people what it is you're going to do with the information and their right to keep it up to date and all the rest of it. Whilst consent is not necessarily important under all circumstances, you do need to tell people what your policies are about that. The other issue that we saw, and this used to be my attitude, all data is good, keep as much of it as you can. That's what I used to tell people. But now we realize under POPI and other data protection legislation, to be perfectly honest, that data itself has a liability associated with it. There's a danger there. If you have a data breach, if you have information that you should not have because the person that you're holding it on doesn't know you have it, then there's a liability there. So really it's about keeping things tidy as well and making sure you don't have information that you don't have a justifiable purpose to store.
So one of the elements of the POPI Act is it says that you may not keep information beyond the purpose for which it was given. You're supposed to destroy it. So now I give you my CV in application for a specific job. And you then come back to me and say, Rolly, thanks for your interest, but you were not successful. You should then destroy that information. You should delete it according to the Act. And I'm probably like you. Information and databases can actually be a liability rather than an asset, because everybody seems to want to have large databases, and the bigger the better. And I think that's wrong. I don't think that works at all. So now I think what we need to be doing is saying to somebody, oh, Shane, I found your CV on LinkedIn. May I keep you on my database? And you say yes. But I need to maybe say, may I keep your CV on my database for future matching purposes? And you say yes. And You sign my application form to that effect. Now, I say what I've done is I've created an evergreen situation. So I've got your CV in my database, and then if somebody comes and says, you shouldn't have it, I say, but why not? Oh no, well, it's beyond the purpose for which it was given. So no, but the purpose for which it was given was for future matching. So that stays evergreen. So that helps them. Although, to my mind, just simply keeping lots of CVs for the comfort of having a big database doesn't actually work.
There is a requirement under the legislation, as I understand it, that your information has to be up to date. Whilst you're saying you've got consent to store information in perpetuity, in reality, and we all know this as recruiters, CVs and personal information has a shelf life because people's careers change and their objectives change. So even if it's not a legislative requirement, there is a common sense business requirement that your information has a shelf life. And so that you want to maintain a relationship with people so that your information is up to date. So sometimes when we talk about POPI and personal information, what we're actually talking about is just being good at your job and good at your information management. Would you agree?
I think you need to, if you're going to keep a database of candidates, I think you need to manage that. Don't just keep piling names in there and now you're getting comfort because it's big. What you said earlier on was, hey, but that's a liability. I need to make sure that the quality of information is correct, which means actually, and what we're saying to people is, if you have a system, you need to have an automated process that says every 6 months, you need to be sending an email to your candidates to say, we still have you on our database. Has your information changed in any way? Do you still want us to keep you there? That's what should be happening. And now, the bigger the database, as you said, this can become a liability because now you've got a lot of CVs to manage. That's actually good recruitment practice. If you want to keep a database, make sure it's up to date.
Absolutely. This is probably my business intelligence software is involved in information management, and our emphasis has always been on, it's not about storing information, it's about doing something useful with it. And the concept of keeping your data up to date is a big part of that. Let's talk about the liability issues, if we may, because under POPI, there are penalties. Under GDPR, so if anybody's taking information on a European citizen, you're responsible for GDPR as well. There are big liabilities associated with that. And then there's also liabilities associated with if you have a data breach, if you lose information, if information is being used for purposes that were not the intention of the data subject. All these liabilities are there. Where do you see the main threats here?
I guess as recruiters, what we're getting is a complete profile of an individual. We probably have a more complete profile of an individual than lots of other people who are keeping data. And the whole thrust of GDPR and POPI is anti-terrorism. They're trying to prevent somebody's personal details being stolen for identity theft purposes. And the reason they want to steal identities is to open bank accounts and launder money. So that's the whole thing. And we need to protect against that. We need to make sure that the information we have under our control is only being dealt with if you're sending it out, whether it's across jurisdiction or whether it's just to the client across the road, it doesn't matter. You need the consent of that data subject or that candidate. And then you need to make sure that your safeguards are in place to protect that information against improper use by anybody, whether it's one of your own employees or somebody hacking into your database. I hope I answered your question.
Absolutely. Tell me this now. If you advertise for a job and somebody applies, you can get them to accept your terms and conditions. And part of your terms and conditions could be that you store their data and process it for the purposes of that application. That's fine, understandable. But what if you are involved in sourcing? What if you're involved in going out and searching the internet or LinkedIn or job boards or any source of data that you can gain access to, and you don't have consent? And maybe you're dealing with real senior executives who won't take your phone call, but you want to map their careers. Uh,
Yes.
is that allowed, or is POPI going to outlaw that type of practice?
Interesting. One of the presentations I gave recently was to a search firm. And they were saying, "Wow, but this is our business. We go and map the market for a client, and then we send those profiles to the client." I said, "Well, do you have the consent of those candidates?" "No, that's not our business model." I said, "Okay, then you're at risk. If you go and get somebody's information, I think gathering people's information to map the market for yourself is fine, as long as the information you've gathered is in a secure place, and you're not dealing with that without the consent of the candidate. Once you further process that by sending that information to the client, that's where you're going to run into a problem. If you don't, you need the consent of the candidate. If you haven't got it and you compromise the candidate's position, you're going to be up the creek without a paddle, I think it might be. Because when the regulator comes and knocks on your door and says, "Listen, we have a complaint against you. You've released somebody's information without their consent, and you compromised their position. They've lost their job, or some similar thing. You've released their information." "Well, yes, we did. It's checkable. Where's their consent?" "You don't have it." "Oh dear." Now, and you know how big the fines are under GDPR. They're just as big here. And prison sentences. Big prison sentences, big fines, in order to make it a real deterrent against using somebody's information improperly.
Super. Well, so in summary then, Rolly, if you were going to give advice to a recruiter, what are the 4 or 5 things that recruiters should be doing now to protect people's data and get themselves in a more professional position with regard to data privacy?
The 5 things: consent, 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 consent. I think one of the things I say is that the one thing that trumps everything else, if you have the consent of the candidate to deal with their information, you're on the high ground, morally and legally. If you have their consent and get it somehow. And I know people sit there and say, "Oh yeah, but I only dealt with him on the phone." Well, okay, send him an email. Send him an email and spell it out and ask for him to reply. Or, yeah, maybe he won't reply, but at least then say, "This is what we're going to do. This is what we've agreed telephonically. And if you have a problem, you need to get back to me within 6 hours," or whatever it is. Otherwise, it will be taken as your consent to release your details on your behalf, as set out above. So you need to be able to have a paper trail that says, "I reasonably got consent from this candidate." That's the one thing. The other is protect the information. When CVs come into your possession, make sure that they are locked away, or that ideally in the modern world, capture it into your database and then destroy that hard copy. And then make sure that your database is secure. And if it's somebody, a third-party provider that's giving you database facilities, get a certificate from them to say, "Yes, we have firewalls and safeguards against breaches, so your stuff is safe." That's probably it in a nutshell.
Speaking as one of those providers of database software, there's
Yes.
I would strengthen that argument a lot. The issues around data security are something that are front and center of my mind most of the time, and the amount of effort that we go to protect data, not just from data privacy point of view, but from it's information is the lifeblood of the recruitment industry. The way that it's protected, the way that we constantly review and refocus on the systems that we have of protection in place does take up a lot of time, a lot of effort, and a lot of cost. And so having a really reputable firm behind you and having reputable firms behind them as well, because it's a supply chain of data management, is very, very important. And whilst we do a lot to take that hassle away from our clients, I would always recommend our clients to investigate as thoroughly as possible, because they need to understand where the chinks in the armor of data security are. The amount of hacking and all the rest of it is just absolutely astronomical these days, and the risks are so high.
No,
Rolly,
absolutely.
tell me, you run the workshops with ABSO. Maybe you can tell me a little bit about those, how people find out about it, and what the benefit is of attending one of those workshops.
Okay, so we designed a workshop that uses recruitment terminology, because I'm sure you've read GDPR. There's all sorts of terminology that they use in there. Like, for example, they keep talking about the data subject and further processing, and after a while, it starts to get difficult to understand. So we designed a workshop. It's about, the presentation itself takes about 40 minutes to an hour, and then we have a question and answer session after that, which is another hour. So it's quite short. It's about 2 hours in total. It's priced very effectively for our members. It's a fraction of what most other people are doing POPI training at. And more than that, it touches on the important parts of POPI, but it does it in a way that is very practical. So it says, what does this mean for your business, and what can you do to protect your business going forward? And we go one step further. We provide a whole lot of templates that people can use in their business, candidate representation letters, client cover letters, because there's an interesting point. Remember, when we send a CV to a client, they now come into possession of a candidate's information, and they are bound by POPI to protect that information, to keep it safe, to keep it secure, and to not further process it. So, hey, Mr. Client, can you now take this CV and refer it to your friend in another division or your colleague in another division? You may, but only with the consent of the candidate. Otherwise, you are in breach of the law. You are in breach of POPI. And one of the things that we emphasize a lot is get your client to act upon the CV. Even if they say your candidate was not successful, regret him. And once you do that, you must delete that information. So there's some client management principles that we put in place. And we provide templates for that as well, templates to help our members. So it's a very practical, very useful course.
And how do people find out information on that course? Is that's on the ABSO website?
It's on the ABSO website, but we also put it out to our members. So we send out emails, other communications to say the time you attended an ABSO POPI workshop, to get up to speed with legislation and make sure that you protect your business.
Well, that's wonderful. Thank you so much for your time today, Rolly. I think the information that you've been talking about is massively useful to people in the recruitment industry. POPI is coming, but that doesn't mean that you shouldn't be acting on it right now just because it's not enforced in legislation. There's lots of things you can do to protect your information, operate as a better recruiter. Hopefully, we'll be producing more video content, more blog content over the coming periods of weeks and months ahead to improve people's data protection and data management. Thank you so much for your time today, Rolly. It's been a pleasure talking to you. And if you want more information, you can check out Roly on the APSO website, or indeed check out our website, intel-sw.com, or contact me. I'll be more than happy to help. Thank you for your time.
Good. Thank you, Shane.